Great, thank you. Welcome. We are very excited to hear from you guys today. My name is Darcy Kern. I am a professor of history at Southern Connecticut State University, and I'm also an alumna of the program.
Good afternoon and congratulations for making it to the national finals. My name is Jamie Gass. I'm director of the Center for School Reform at Pioneer Institute. It's a Boston-based think tank.
My name is Tim Isaacs. I am executive director at the Center for Teaching the Rule of Law at Roanoke College in Salem, Virginia. Welcome and good luck today.
Could you guys please introduce yourselves and your teacher?
My name is Ella Maddox, and I'm a junior at the Williston Northampton School.
I'm Soren Rutherford.
I'm Avi Kacker.
I'm Chris Ludicky.
I'm Nick Desai.
I'm Connor Hagness, and this is our teacher, Mr. Peter Gunn.
Good luck, guys.
Great, so I'm going to read the question to you, and then we will listen to your prepared answer and ask you some follow-up questions. So, question 2. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? You may begin.
No free man shall be imprisoned except by the lawful judgment of his peers and by the law of the land. At first glance, this quote may seem to be from the Habeas Corpus Act or the Constitution, but it is in fact from the Section 39 of the Magna Carta, the earliest mention of habeas corpus. Since then, habeas corpus has become one of the most important tools in ensuring that personal liberties are not being violated in order to secure individual freedom against arbitrary executive power, which connects to the revolutionary principles of natural rights, constitutionalism, and due process.
The writ of habeas corpus is a court order mandating that a defendant receive due process of law. This ensures that the authorities may not unlawfully detain a defendant and must bring them to court with adequate evidence that a law has been broken. If there's evidence, a trial is held. If there's not adequate evidence, then a defendant is set free. Habeas corpus is essential to the principle of limited government, as it supports the notion that the U.S. government can only act under the word of the Constitution. The Constitution states in Article 1 that the privilege of habeas corpus, the privilege of the writ of habeas corpus shall not be suspended.
The Constitution, which was put in place to protect individual freedoms, limits the government's ability to deny the right to freedom from unlawful detention, but it does not entirely limit the court's ability to regulate habeas corpus, as the Constitution goes on to say, unless when in cases of rebellion or invasion, the public safety may require it, alluding to the law that courts cannot deny the right to habeas corpus to inmates who are unqualified.
Habeas corpus has evolved into a fundamental right by preventing unlawful and infinite imprisonment, which further protects citizens' individual liberties. In 1641, the Massachusetts Body of Liberties first alluded to the writ of habeas corpus as it stated, "No man's person shall be arrested, restrained, banished, dismembered, nor in any ways punished, unless it be by virtue or equity of some express law of the country," further establishing a legal code for judicial processes before it was even outlined by Parliament in 1679 as British higher law. During the Civil War, Abraham Lincoln suspended this right, as Justice Taney responded by saying, "I can see no ground whatsoever for supposing that the President in any emergency or in any state of things can authorize the suspension of the privilege of the writ of habeas corpus."
Despite being put in place to protect the rights of the people, there have been instances where habeas corpus has been abused. Ex parte versus Merriman challenged the president's authority to suspend the writ of habeas corpus during a national emergency, resulting in the verdict that the Constitution grants this right solely to Congress. Additionally, in Ex parte versus Milligan, it was ruled that the federal government was unqualified to set up military courts where there were functioning civil courts, thereby denying citizens their right to a fair trial by jury. The court decided that only Congress could suspend habeas corpus and that civilians were not subject to military courts, even in war times. Habeas corpus does not entirely limit the government, but offers a limitation that corresponds with the principle of limited government.
Acts have been passed in order to protect citizens' rights to habeas corpus. The Judiciary Act of 1789 granted courts the power to issue habeas corpus in all cases where any person may be restrained of his or her liberties in violation of the Constitution or any treaty or law of the United States. The 1960 legislation was enacted limiting the instances in which habeas corpus could be denied and establishing new lines of appeal that strengthened its protection.
Cash bails are an example that help prevent the unreasonable detention of criminal defendants, but currently states have been abolishing them in courts as it represents equality, not equity. Cash bails do not account for the amount of lower-income lower income citizens who are unable to pay these bails, as the wealthier citizens are more likely to be able to afford it. Despite the lack of equity, the suspension of cash bails is unconstitutional under both the Equal Protection Clause and Due Process Clause, because it denies individuals the right to freedom from incarceration, ultimately violating the natural rights to liberty and equal protection of the law.
Habeas corpus places an unreasonable burden on the U.S. government in cases where providing evidence is a breach of national security. A prime example being Rasul versus Bush, where 4 foreign men were being held at Guantanamo Bay without charge, trial, or access to counsel. The case resulted in the U.S. courts having jurisdiction to hear habeas corpus petitions filed on behalf of all foreign nationals imprisoned at Guantanamo. This gave the inmates the right to habeas corpus and the ability to challenge their detention. This was a burden because the government de facto did not want to allow this, but de jure had to grant habeas corpus. Thank you.
We're now ready for your questions.
Great, thank you. I have several because you raised a lot of interesting points, but I'll start with this idea of a breach of national security that you mentioned. Who determines what a breach of national security is? And is it possible that the government can use the term as a means of limiting habeas corpus and reimposing arbitrary government?
Well, habeas corpus has been suspended 4 times throughout the history, and I feel like during those 4 times, it was justified in every single one. And so I feel like when habeas corpus is suspended, there is lawful behind it.
Habeas corpus is suspended particularly during a wartime or during a case of like a national emergency.
For example, Abraham Lincoln suspended it during the Civil War, and also President Roosevelt suspended it during or after Pearl Harbor events.
When James Madison, the father of the Constitution, was president during the War of 1812, New Englanders threatened to secession, and the British even burned the White House. Still, he never suspended habeas corpus or abridged domestic civil liberties. Why do you think President Madison showed so much constitutional restraint during wartime?
I think that the right to suspend habeas corpus is mostly given to Congress and not like really to the president. And this is seen because it doesn't say this exactly in the Constitution, but where it is placed in the Constitution is very important, because they were originally going to put it in Article 6, but they ended up putting it in Article 1, Section 9, and Article 1 starts off with the legislative branch.
Right. And also, I feel like we mentioned this in our paper, but when President Abraham Lincoln suspended habeas corpus, it was frowned upon by the Supreme Court, as Justice Taney said. And I feel like just that example there, it shows how Madison did it the right way versus Abraham Lincoln went a bridge and went his own way with it, and that was frowned upon.
In addition,
Also, about just suspending, an example of when no one had the right to suspend the habeas corpus was in Myanmar, due to the fact that under a state of martial law, like the right of the military to hold the people, because they thought that the people were dangerous. So in a sense that people who are dangerous to our country, there's no one who is allowed to suspend the habeas corpus.
also to answer your question about James Madison and the British, I believe that James Madison knew that the origins of habeas corpus in America came from the British, and that if he were to suspend habeas corpus for the British, then they would have 100% argued against it and petitioned against his actions if he had suspended it.
What are some other constitutional guarantees against arbitrary incarceration?
Well,
I think you can go, Avi.
Well, to answer your question, several amendments in the Constitution support the idea against arbitrary incarceration. And
For example, the Fifth Amendment protects from the right of self-incrimination. And for example, in the case Miranda v. Arizona, the Supreme Court issued that police officers have to inform you of your rights before interrogating you.
Right. And also going along with what Soren was saying, I feel like the Fourth Amendment, the search and seizure, I feel like this is very crucial because there have been cases where it has been dismissed based on procedural processes. So I feel like that would be a good example. And an example of this would be Katz versus the United States, where he was dismissed because they had tapped the phones of public, they tapped public pay phones, and that was seen as unlawful because that was public information and it wasn't private. So his case was dismissed based on that the government gathered information unlawfully.
Any other examples you can think of?
Well, yeah. So recently, I don't fully recall the case, but with Facebook in the recent years, there have been arguments against Facebook and their access to people's accounts and their privacy. And I know that, for example, there was also with Apple, there was a case where a man was convicted of a crime, and that the court ordered Apple to unlock his iPhone and give them information to help them with the case, but Apple declined, saying that it was an invasion of the man's privacy.
Okay, thank you. Another question. Oh, I'm sorry, go ahead, Darcy.
No, you guys mentioned in your statement something about unqualified inmates who are unqualified for habeas corpus. And I wonder if you could talk more about that. Who are these unqualified inmates and why are they unqualified?
Right. So I feel like in the court system, it doesn't define how many times an inmate can request habeas corpus. And there have been multiple instances where they unless new information has been presented, they're still trying to request habeas corpus, and that it's been denied. And it's a rare occasion where inmates are granted habeas corpus a second time based upon new evidence coming in.
I think that a lot of people that are trying to request habeas corpus and get their case reviewed are people in Guantanamo Bay and people that feel that they've been unlawfully convicted without a fair trial.
And then
Adding on top of that, in Abbott versus the United States, it goes back to the double jeopardy clause of the Fifth Amendment, talking about how you can't have the same, you can't be in court for the same thing twice. And the reason this court case was so important was because it violated the double jeopardy clause of the Fifth Amendment, which is why habeas corpus is so important.
I also just want to add that there are a couple cases that we know of, like Jones versus Mississippi, which is one that happened, I think 3 days ago now. They just they retrial for it, and he didn't get he wasn't freed from it because he killed his grandfather when he was 15, and he's still in prison today. And they just re-upped on it. They just had another hearing, and he's still found guilty. Whereas with Miller v. Alabama, which was about the same thing, just in 2012. But when they had his retrial, he was eventually freed because they said it violated cruel and unusual punishment. So there's just different classifications where if new evidence is provided, you can get a new trial. But it depends on the case, and it doesn't seem to always be 100% written in stone what the different cases are, depending on who it is and what the case is.
I just want to quickly add that it's up to the discretion of the judge to oftentimes decide where to apply certain amendments or rules.
Thank you.
Thank you.
thank you.
Great, thanks. That's actually a great way to end it because we have a common law system where the judge has tremendous discretion. So that was a nice closing. You guys, this was very good. You gave a lot of examples, both in your prepared speech and in your follow-up. I thought it was interesting that you talked about cash bails, this idea of unqualified inmates. And you gave a lot of good points in your follow-ups. This answer to my last question was fantastic. I thought bringing up Burma or Myanmar, whichever way you want to call it, was good because you said that the government says the people are dangerous. Well, but the government can say that whenever it wants, right? And so this is, I think, the very fine line that is drawn between the government and the people and our rights and the necessity for the common good. So great job. This was very interesting.
Thank you so much.
I'd like to, first of all, thank you and your excellent teacher for all of your hard work getting to the national finals. This is a very difficult question, I think, and I think you handled it very, very well. In the introductory portion, I think that you hit a lot of the high notes in terms of, beginning with the section from Magna Carta, citing the specific article in the Constitution. I like how you mentioned the Massachusetts Body of Liberties and drew in the colonial experience, as well as the Judiciary Act. And I thought that the way in which you handled my question on Madison and the War of 1812 was excellent. That's not an easy question. It requires some historical knowledge, and so you should be very, very pleased. I thought you're particularly strong on your court cases too. So you should really be commended. You did an excellent job.
Thank you. None of this would have been possible without Mr. Gunn as well. So
I would simply echo what my colleagues have already said. I was very impressed with the very beginning where you used the quotation from Magna Carta and then explained that while you might think it was from the act itself, that it was much older than that. I would suggest, and this is just a mechanical thing, slow down your presentation a little bit. It's really difficult as a judge to take the kinds of notes you want to take in order to give feedback. And, you're a century ahead of where we are with our notes, perhaps. So that was just a suggestion. I thought you did a really good job with the court cases. I thought you answered my question about arbitrary incarceration really well. And I also like the idea that you brought up Myanmar, because, Myanmar is sort of an abuse of the whole process, and by flipping it on its head. And so it was really clever of you to insert that. So job well done. And thank you, gentlemen, for helping out. This has been our large group. So thank you.
Thank you so much.
Thank you
We
very
appreciate
much.
your
You're
time.
welcome.
Thank you.
Thank you very much.